It isn't every day that all 13 provinces and territories speak with one voice, lobbying the federal government on a national matter. But after the slaying of an OPP officer last month, they spoke with one voice, asking for an overhaul of the rules that permit those awaiting trial to be granted release from custody. With us now on the advisability of bail reform, let's introduce our guests, and as is our custom, from furthest away to closest to our studio, starting in Montreal, Quebec, with Laura Berger. She's a staff lawyer at the CCLA, the Canadian Civil Liberties Association. In Bracebridge, Ontario, Jeff Lehman. He is the chair of the District Municipality of Muskoka. In King City in York Region, Jim McSween, Chief of York Regional Police and Vice President of Ontario Association of Chiefs of Police. And here in our studio, Teresa Doncor, criminal defense lawyer at Rudnicki and Company. And Teresa, we're very happy to have you on the program for the first time, and to our guests in Points Beyond, thank you for joining us as well. Chief McSween, I'll start with you. There are many groups now calling for bail reform. Your organization, other police associations, provincial leaders, Doug Ford was very much all over this. Tell me what your concerns are about the status quo.
Well, thank you. Thank you for having me. The concern generally is that chronic offenders, those charged with violent crimes in relation to firearms offenses, we are seeing as police organizations, not only here in Ontario, but across the country, more and more offenders in those categories finding their way back onto the streets when, in fact, we believe there's an argument to be made that those are the types of offenders who should be kept in custody. The pinnacle of any of these decisions around bail should be shone through the lens of public safety. And in some cases, that doesn't appear to be always the case when decisions are made around release. We do agree it's a system that needs to be balanced. There is a charter, which obviously has to be a priority as well. So a balanced approach to bail, and something that's more specific to chronic repeat offenders around violent crime and gun crimes that does a much better job of keeping the people in that need to be kept in and allowing many others to be granted bail as we agree they should be granted bail. So that's what we're looking for, and that's there's a lot of work to be done in that area.
Okay, Laura Berger, let me pick up this issue of balance with you, and I wonder if you could give us some of the background here, in as much as did the federal government make some changes to the bail system that, in your judgment, have led to these criticisms?
Yeah, that's a great question. So a lot of folks have spoken about Bill C-75, which was a bill that came into effect in 2019 and that made some changes to the criminal code. But I think what's really important to understand is that the fundamental principles regarding bail have not changed since the Bail Reform Act was introduced way back in 1972. So there are different reasons that someone can be denied bail and detained prior to their trial. And remember, that's a stage when the person is legally innocent. They have not been found guilty of the allegations that they're charged with. And our criminal code already says that individuals can be detained if there is a real risk to public safety. And that is a principle that's been well established in criminal law and that has not changed. In 2019, the changes to the criminal code, in fact, were criticized for not going far enough in the sense of not counteracting a really restrictive and risk-averse bail system. There were some additions to the criminal code which really codify existing principles, such as the principle of restraint. And that simply means that any restrictions on a person's liberty before trial have to be really justified. And if they're not justified, the presumption is that we release people on with as much freedom as is necessary and appropriate in the situation.
Okay, let me move on to Jeff Lehman now, because you are the one person in politics among our group here today. And this has become an enormous political football since the tragedy related to the OPP officer. The leader of the federal Conservatives, Pierre Poilievre, has likened the current situation to what he calls a catch and release policy. Do you think that's a fair assessment?
No, I think this is a very complicated issue, and it requires a nuanced discussion. That's harder to have in politics these days. Last year, Ontario's big city mayors, of which I was the chair, both called for bail reform, more stringent conditions, and the kinds of changes that Chief McSweeney is talking about, and at the same time called for decriminalization of simple possession. You can hold both of those positions at the same time, but it requires a nuanced and more thoughtful discussion than the kind of sweeping statements that seem to be are being thrown around right now. But I would say that my colleagues in the municipal sector, many mayors, and our mayor's caucus were unanimous in calling for more stringent conditions to prevent the release of the most serious violent offenders. And I think one of the nuances here that's so important, Steve, is we are talking about the most dangerous individuals. You saw BC's Attorney General about 3 or 4 months ago say that one of the unintended consequences, seemingly, of Bill C-75 was that some of the most serious offenders were being released. That's the kind of change that we need to make to protect our communities. But there's a much bigger issue here about who's in custody and why, and how can we get people to trial sooner, for example, which would affect the broader situation and the number of people who are in jail, in custody on remand.
Okay, let's go to Teresa here in the studio because we want to get your view from the front lines, obviously, on how this works. Can you sort of take us through how it works when somebody is charged and what, for example, is under consideration, whether they're granted bail or not?
Sure. First of all, thank you for having me and thank you for tackling this important topic. In terms of what the assessment is on bail, the courts consider 3 criteria. First is whether that individual is a flight risk. So in other words, whether their detention is necessary in order for them to show up to court, to show up to their trial. Second is public safety. So whether there's a substantial likelihood that that individual will commit another offense that could endanger the public. And third is the public's confidence in the administration of justice. And that the basic idea there is if someone is so obviously guilty of a very serious offense, they shouldn't be released on bail. But that factor should come into play in very few circumstances.
Do you have a view on whether those three criteria were met as it relates to the case of the OPP officer recently slain?
Well, I don't know the underlying facts of the case and the underlying what happened at the bail hearing, but each case has to be assessed on an individual basis, and it really is a weighing of these factors in a risk assessment. And you know, all of the facts could have led to that person's release, and it could have justifiably led to that person's release. But at the end of the day, it's a process of trying to minimize the risk as much as possible. It's not an absolute.
Mm-hmm. Chairman Lehman, is it pretty obvious that whoever did the risk assessment on the situation regarding the constable recently slain, they blew it?
Well, again, I don't know enough of the facts of the case to say whether they blew it, but I can tell you the system blew it, where we have individuals who are obviously a threat to public safety, who are a threat still, individuals who are threats to their intimate partners. You know, the mayor's call for bail reform was more than a year ago, following the case in Brampton of a woman who was slain by her partner, who had been released 4 times after serious offenses. And there are a lot of those cases, and they get a lot of attention. So to me, it is a systemic issue that we do have either unintended consequences of the bill or other problems with our system that are allowing some of the most serious offenders to be released. Again, this shouldn't overshadow the broader and much more important discussion around the whole court system and time to trial. But it is clear from the number of cases we've seen over and over, and you can hear the public concern. I really believe that the public's concern about this is widespread.
Let's understand, Laura, well, I hesitate to use the guy's name, but here's his name, Randall McKenzie. He's the man alleged to have killed the OPP officer in question, and he'd been released on bail. And I wonder, and again, he is presumed innocent until proven guilty in a court of law. But let's just ask the overarching question. How typical is it for somebody out on bail to go out and commit a violent offense while out on bail?
That's a great question. And I'm not aware of any comprehensive data that would indicate how common this kind of situation is. I can tell you the data that I am aware of. In Ontario, on any given night, more than 70% of people in our provincial jails are legally innocent. They're there on remand. They're either waiting for a determination of their bail or they've been denied bail and are waiting for a trial. And it didn't always used to be this way. 20 years ago, the majority of people in provincial and territorial jails had been found guilty and sentenced to an offense, and they were serving a sentence for something that they were found to have done. So when we talk about our overcrowded jails and our bloated justice system that is slow moving, where people charged with relatively minor offenses are spending a lot of time in custody, part of that and a big driver of that is the increase in remand detention. And I think it's really important to think about the vast majority of the people who are in this situation. And we've heard this, this morning, which I think is really important. The vast majority of people are not being detained and are not in jail and haven't been charged with exceptionally serious violent offenses. We see a pattern of people being released on bail and then rearrested for breaching their bail conditions. That underlying conduct might not itself be criminal. So for instance, if you are released with a curfew and you breach that curfew, you can be brought back into jail. You can be rearrested and charged with a new criminal offense for being out on the street at 11 p.m. And I think it's really worth thinking about what the data tells us, because the criminologists would tell us that our bail system in Canada has not become more lenient over time. In fact, it's become more restrictive and more risk averse, leading to more people spending time in jail while they're legally innocent and before they've been convicted of anything.
Okay, Chief McSween, maybe I can get you to weigh in on this. Do you have either hard data or do you have sufficient anecdotal evidence based on your experience as to how often people who are out on bail commit violent offenses while on bail?
Well, let me just give you this statistic that specific here to York Region, not across the province, and there's a lot of work being done right now to compile these statistics provincially. But in 2021 in York Region, we as an organization seized 121 violent crime handguns, okay? As a result, 31 of the offenders who we charged with offenses related to those guns were out on a court order of some sort. So that's a quarter of the people who were responsible for the crimes related to those guns were reoffending again, once again, in relation to the gun charge, already being on either bail or another type of court order. So it goes to show you that people are not abiding by their conditions. And the reality is what we're seeing across the province is more and more people who are charged and with a violent crime and are released on bail are back before the courts again, breaching their bail and again and again. And the problem with that is the types of offenses they're responsible for or alleged to have been committed are violent crimes. We are not talking about the majority of people. We're talking about that one section of people who are not adhering to their bail conditions, are essentially kicking sand in the face of the justice system and knowing that in all likelihood, they're going to get released again. And I can tell you in many cases, they come before the courts for a judicial bail review 30 to 90 days after they've been detained. And moreover, they are released once again back into the community. So, there's work to be done in that one lane, but it poses a significant public safety risk. And we're seeing that play out time and time again.
And just so I'm clear, Chief, it would be your view, I presume, that quarter of offenders who were originally charged with the possession of guns related to violent circumstances, they should not have been out on bail. Is that your position?
Well, I guess the point I'm trying to make is that when they were charged with the crime gun offense, they were on a release already. And that's the point. The point is they were not abiding by the conditions, and here they are again back before the courts on a charge related to a firearm. That's unacceptable, and that poses a significant risk to the community. And
Gotcha.
Yeah.
Okay, let me get Teresa on that, and then I want to hear from Laura as well. You heard the Chief's concern. Is that a legitimate concern in your view?
Well, I think where the chief and I can agree is that the current system isn't working. The criminal justice system isn't effective in preventing reoffenders. And the issue is that the criminal justice system doesn't get to the root of the issue. I think if we want to deter violence, we have to address the root of the issue of violence. And violence is often born from inequality in our communities. I think really to get to the root of the problem, we really need to be addressing the social and public health concern that is born from violence. So we need to be investing in mental health and addiction services. We need to be investing in guaranteed livable income. We need to be investing in safe housing, public washrooms, and all of these social services that keep our communities safe and healthy.
You are no doubt correct about all of that. But that will be a 10-year project and will not solve the problem tomorrow, and people want a solution tomorrow. So what do we do in the interim?
Well, quite frankly, I don't think that there is a solution that's going to fix this tomorrow. This is a complex issue and it's going to take time. And I don't think that rushing to find a solution such as stricter bail is really going to solve the issue of violence in the city. I think we need to take the time and do the hard work and invest in services that are really going to actually keep our communities safe in the long run.
Laura Berger, what's your take on that?
I would absolutely agree that crime and public safety is a complex social issue and there are no easy answers. We can amend the criminal code and that still won't get to the heart and the root of what causes crime. I absolutely agree, unfortunately, that there are no Band-Aid solutions. At my organization, the Canadian Civil Liberties Association, we've been doing research on the bail system for over 10 years. We're working right now on a grant-funded report. I spent last summer interviewing, almost 40 justice system participants in 5 different jurisdictions across Canada. And I can tell you that the people who work in the system, whether it's service providers who provide bail supervision, whether it be lawyers who work in bail court day in and day out, they point to a complex web of interrelated issues. And crime can't be teased out from other social issues. What I heard again and again was that revolving door, those people who are in and out of custody, part of the problem is that we don't have other systems for these people, right? When we're talking about people dealing with mental illness, dealing with addictions, people living in poverty, people who have precarious housing, when they get released on bail, often it's without support, it's without a place to go, it's without stable housing, it's without a way to get food or to get medication and treatment. And that leads them back into the criminal justice system. And I think it's really important to think about those stories too, because a lot of the time in this area, our decisions can be driven by these really high-profile tragedies, which are shocking and horrifying. But at the same time, a lot of stories don't make the headlines. And so I think about cases like a First Nations woman from the north of Manitoba who spent 51 days in pretrial custody, single mom of 4 kids, lost her housing from Norway House, Manitoba, and then is released, and ultimately all those charges are dropped, right? We don't hear those stories, and we don't hear about the lives that are disrupted, the jobs that are lost, the housing that is lost. And that instability and that trauma then creates issues and can create crime as well. So I think we need to be hearing those stories and looking for balance and looking for real enduring solutions.
No, I totally take your point. And Jeff Lehman, let me get you back in here. I know as a political leader, you're the former mayor of Barrie. You now have your responsibilities in Muskoka, and you have to make policy. And I understand that if you want to have a nuanced conversation about something, that you can't make policy on the basis of one-offs. Even if they're shocking, you've got to take a preponderance of evidence over time in order to make smart decisions. Having said that, we don't have 10 years to fix this, and I understand that education is a problem, and social services are a problem, and mental health is a problem, and corrections are a problem. We get all that, but your constituents will want something done about this immediately. What do you say to them?
Well, I actually happen to agree with Laura that one of our issues right now is an overemphasis, a risk-averse approach at what I would call the low harm end of the criminal justice system. And what we need to do is provide more social service and support to keep people out of the criminal justice system at the low harm end of the spectrum, and focus our policing and criminal justice resources on high harm offenders. Where I might differ from them is I don't think we need to wait to build those supports up to focus on the high harm offenders who are committing these most egregious crimes. I think when we're talking about somebody who is a repeat violent offender, we can, in that narrow lane, as our police chiefs have suggested, focus on being tougher on that small but most dangerous high harm population, while we simultaneously work to reform low harm criminal justice and move people out of the criminal justice system and into social services and mental health supports. That is the shift in balance we need in this country, where we are tougher, more focused on high harm, and decriminalize in many ways the low harm offenses that need to be addressed by mental health and addiction supports and social services.
Let me ask the York Regional Police Chief this then. You're probably not going to get into too much of a debate about whether or not violent people suspected of extremely violent crimes ought to be held in prisons and not sent out on bail. However, we really don't have enough places in our prisons to keep everybody awaiting trial who's been arrested on nonviolent charges. So my question for you is, do you think there are reasonable circumstances on which to hold people in prison, in some cases for weeks or months, awaiting their trial dates, if they in fact have been arrested on nonviolent charges?
Well, I guess the point you're making is if they've been charged with something that's nonviolent while on conditions, I don't think we want to over inundate the jail population with anyone that is charged with nonviolent crimes. Those are probably the groups that we're talking about where bail is appropriate, if I'm answering your question correctly. It's that other narrow group that we just spoke about, and I couldn't agree more with a lot of what the panelists have said about social services and long-term planning. That has to be done as well, and we want to be part of that. But we're talking about the most egregious offenders, the most chronic offenders here who pose the most significant threat to public safety. That's what we're talking about. And if we can do work in that lane, and some of that work needs to be investment at the Ministry of the Attorney General, more crowns, more education for justices of the peace to know how to apply principles of bail appropriately. I think those are some of the immediate steps that need to be taken to sort of help with the situation where we are now, and do a full review of the bail system and find where are those opportunities for improvement immediately, so that the public has trust and confidence in the process, in the system, and that we all can agree that the people that are held in custody should be there until trial, or until a review, and then likely held until trial.
Okay, Jeff Lehman, let me stay in this lane then. The public presumably wants somebody held accountable for the fact that an OPP officer is dead now who ought not to be dead, because it's possible, if in fact this person accused is found guilty, that he was killed by somebody out on bail. Who do we hold accountable if someone commits a violent offense while they're out on bail?
Well, the person should be held accountable for their offense, but for the systemic failing that allowed them to be out on bail, it's the federal government on the content of the criminal code, but it's also the provincial government. What we haven't talked about a lot here today is time to trial. Part of the reason that people are detained so long is because of the decades long, and it's been governments of different political stripes, the decades-long underinvestment in the criminal justice system, the court system, which has now resulted in that statistic of 70% of the population being held on remand. If time to trial was shortened, not only is the system fairer for everybody, but the number of opportunities to offend is just by definition going to be reduced. But that's one of the major underlying issues. So you ask who should be accountable for the systemic failures? There's a lot of fingers pointing at Bill C-75. I think the issue is more complicated than that. And a big issue is time to trial and the slow court system. So when Ontario's big city mayors passed resolutions on this last year, we passed two. One calling on the federal government for criminal code reforms. The second calling on the Ontario government for investment in the court system. And I think we probably, all four of us, would agree that the system could be a lot swifter. I like Chief McSweeney's notion of investment, but I would go further to say that the investment in capacity in our system to allow people to be brought to justice sooner, it shouldn't have had to be driven by Jordan. It's a proper functioning of a modern society to have swift justice. And I think that will address a lot of public concern as well. To have shorter time to trial means a fairer criminal justice system, but it also means swifter justice for those accused of serious crimes.
Teresa, what about Crown attorneys or judges? How do we hold them accountable in these circumstances?
Well, Steve, I don't think that there's any utility really in pointing the finger at one particular party, whether it's the courts or the cops or the government. The reality is, if we want safe communities, we all have a role to play in ensuring that we hold each other accountable, ensuring that we support and care for one another. In terms of Crown attorneys and justices of the peace, I mean, I think I can agree that justices of the peace perhaps need more training on, the bail system, because there are substantial liberties at stake, and perhaps it should be judges that preside over bail hearings. But again, that just will cause or contribute to the already delayed system and in the criminal justice system. And in terms of Crowns, I mean, in my view, I don't think we need more Crowns. I think we need more funding for legal aid so people can more efficiently navigate through the system, because, there are a lot of self-represented individuals, and when there's self-represented individuals, it's extremely difficult to navigate through the criminal justice system without a lawyer. So I think just more legal education in general and more resources for the criminal justice system will help with the backlog. And I'm not sure if it's the solution to bails, but it's certainly a step in the right direction.
You may be shocked to hear this. This is not the first time on this program I have heard about the need for more resources for legal aid in this province.
Yes.
Right. Laura, can I get you to come in here, and why don't you give us some ideas as well on this, and in particular, the ideas that Jeff Lehman just put forward, more capacity for the justice system in the province, certainly makes a lot of sense. What would you add to that?
Absolutely. I would agree 100% that our system could be better resourced. I was nodding very vigorously as Teresa was talking about resources for legal aid, because when we talk about helping people exit the criminal justice system, helping people get connected to the resources that exist in the community, we need legal aid lawyers, we need court staff, we need social workers to do that work. And then that also contributes to court efficiency, because it means that folks are getting the solutions they need instead of showing up in court again and again and again. So I think that's absolutely vital. I think we also need to talk about how we construe crime. Fully 20% of cases, about a fifth of cases going through our criminal justice system, the most serious offense is what we call an administration of justice offense. So that is a breach of a court order or perhaps a failure to appear for a court appearance. That's fully a fifth of cases. And we often refer to these as system-generated offenses or almost manufactured crime, because the underlying conduct may not itself be criminal. And often, again, there's social needs that are at the heart of those offenses. Someone who misses a court appearance, perhaps because these days, a lot of court appearances are virtual. They don't have access to technology, or they're unhoused and can't figure out a way to actually appear and to participate in their court appearance. So if we took that 20% and we found better solutions for those folks, for people who are breaching orders because they're shoplifting to survive, or, they don't have access to stable housing, food, and social supports and services. If we found better solutions for those folks, I think our criminal justice system would be more efficient. Efficiency doesn't mean just adding more resources to shove people through the system faster. We know that that's a recipe for failure. It means really thinking about what interventions are going to serve public safety, listening to the evidence, and listening to the people who work in the system.
Chief, I'm down to my last 30 seconds. Let me give it to you to add your ideas as to what we should do here.
Well, I just want to touch on something Teresa said. There is something to be said about, whether a judge or a justice of the peace should be the one to preside over a bail hearing in relation to somebody charged with a complex violent crime. It always struck me that, we're asking a justice of the peace to do a proper evaluation on some of the most serious crimes that are being committed in our communities, and yet on the bail review, it moves to a superior court justice to do the review. So one has to ask: is it placed in the right hands at the front end when we're asking for some of the most complex violent crimes to be evaluated by, and no disrespect to our justice of the peace, there are many of them that are extremely, very good. But there's a lot of work to be done and education to be had by many to fully understand the gravity of some of these situations, and how in some cases the evidence is right before them to suggest, some of these people are just not going to abide by conditions, as has been demonstrated time and time again. So there is something to be said there. I do want to touch on one other piece. I think innovation in our court system. It's too bad it took a pandemic for our courts to see opportunities for more online sort of, grasping, being online using technology. I think there's a lot of work could be done there to make the system more efficient as well. So those are two areas I think need to be looked at as well.
Gotcha. I want to thank the four of you for joining us here on TVO tonight and sharing your views. Jeff Lehman, the chair of the District Municipality of Muskoka; Jim McSween, chief of the York Regional Police; Laura Berger from the CCLA; Teresa Doncor, the criminal defense lawyer at Rudnicki and Company. All good wishes, everybody. Thanks again.
Thank you.
Thank you.
Thank you.
The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.